Being a small business owner can be incredibly rewarding. It is fun to watch your ideas flourish and grow and bring in income for you and your family. It can be like a dream come true. However, what was your dream may become a nightmare in the event you and your spouse find that you can no longer live together as a married couple. More likely than not, your business is the most valuable and important asset in your marriage. In addition, you and your spouse may have invested your retirement accounts or other savings into the business. Looking back, it would have been a good idea to have signed a prenuptial agreement before your marriage so that each of you could have protected your individual assets from division in a divorce matter. But if you did not do that, what can you do to try to protect yourself and your business while you are going through a divorce? Here are my 5 tips for protecting your small business. First, don't wait. If you or your spouse have even mentioned the word divorce, you could be headed in the wrong direction in your marriage. Once the word is mentioned, it is important to begin counseling as a couple as soon as possible in an effort to save your marriage. However, it is also time to start looking at your business and thinking about what your options may be in the event that counseling is unsuccessful. Second, consult with both an experienced divorce attorney and an experienced business attorney. Businesses have different organization types or structures, such as a C corporation or S corporation, a limited liability company, a limited liability partnership, a sole proprietorship, among other types of business entities. And even within each different type of business entity, there are different forms of operating agreements, partnership agreements, buy-sell agreements, and other types of agreements. Anytime a business is up for potential division in a divorce, the issues are more diverse and complex. As you can see, this makes each case unique and the potential options for resolution unique. That is why it is also important to have an experienced attorney or attorneys who have knowledge of both business and divorce matters. Often, as matrimonial lawyers who concentrate our practices solely on family law, we will bring in attorneys equally versed in business law to make sure all aspects of our clients' cases are managed in the most effective way possible to protect their interests. It is important that you meet with an attorney as soon as possible once you have a reason to believe that your marriage may be in trouble in order to determine the best path forward for you. 3. Post-nuptial agreements. If you do not sign a prenuptial agreement prior to your marriage, you can still sign a post-nuptial agreement after your marriage as long as you and your spouse agree to do so. A post-nuptial agreement is a contract signed by you and your spouse with each of you having separate legal counsel, which outlines what will happen to all assets, property, and income in the event of a divorce, separation, or death. If you do not sign a prenuptial agreement, it is the best option you have to protect your small business in the event of a divorce. Because you are signing this post-marriage and after the likely accumulation of joint assets, it is very important that all assets and debts are disclosed as part of the negotiations to the post-nuptial agreement. Further, it will be vitally important to ensure that the value you assign to your business is accurate and can be supported by evaluation of your business by an experienced expert in that field. If divorce becomes the unfortunate result, the judge will be looking at whether or not any assets were undervalued at the time the parties entered into the post-nuptial agreement if your spouse attempts to attack its validity. So be honest and upfront about the value of your business if you choose this route. Number 4, utilize shareholder, partnership, LLC, or buy-sell agreements when starting your business. It is important that you get the advice of experienced business attorneys to formulate the business organizational documents necessary to protect the interests of the owners, partners, and shareholders. While online legal forms are helpful, they often do not come with the advice on how to protect your business interests in the event of a divorce. One of the many documents that should be created at the time the business is formed is a shareholder, partnership, LLC, or buy-sell agreement. These business structures and agreements can include provisions that protect the interest of the other business owners if one gets divorced. These documents could require the signing of pre- or post-nuptial agreements by any future or current spouses that removes them from having any interest in the business in the future. The agreement could also provide for a mechanism for the purchasing of shares of the business from the partner in the event of a divorce or may forbid the transfer of shares without the approval of the other partners or shareholders involved in the business. While these documents may help protect your business interests, it is important to be careful of the timing of the creation of these documents. If the documents are suddenly signed after a divorce has already been filed by the spouse of one of the business owners, it may be due to being set aside. As such, the best time to get these documents created and signed is at the time the business is being formed, not when you are worried about having to protect your interest. 5. Do not commingle business and personal assets. In the absence of a prenuptial agreement to the contrary, assets acquired during the marriage are generally considered marital property, with a very few exceptions. If you owned your business prior to your marriage, it may be considered to be separate property. However, if the business has grown during your marriage, your spouse has worked in the business during the marriage, you utilized marital funds for your business or business funds to support your family during your marriage, you will likely have changed that business from an asset considered to be separate property and therefore not subject to division to marital property that is subject to division. That is why signing a prenuptial or post-nuptial agreement is so important. However, you can make the impact of the division even greater if you commingle your marital assets and debts with your business assets and debts. Don't use personal credit cards to fund your business or pay for your personal expenses like your mortgage payment, your children's private school tuition, or your spouse's anniversary gift directly from your business accounts. Don't take out a second mortgage on your marital residence, cash out your retirement, or allow your spouse to invest his or her separate inheritance in your business. While these steps alone won't protect the entire value of your business, it may lessen the blow. Your business is your baby. If you have children, you know how fiercely you would protect your children. It is also important to take the steps necessary to protect your business in the event your marriage cannot survive. If you find yourself in a marriage where one or both of you have used the word divorce during an argument or heated exchange, now is the time to take action. Hi, I'm Amber James, founder of New Beginnings Family Law. If you're facing divorce or other family law matters such as child support, child custody, adoption, and more, we want to help.
New life, new directions, new beginnings.